Mr. Deputy Speaker, the bill at hand is focused on bringing into effect the recommendations of the Inter-Ministerial Committee, or IMC, on anti-money laundering, or AML, and in particular, those that relate to AML efforts in the real estate sector. Improving the regulatory framework is critical, not least because the so-called Fujian gang had parked a significant amount of their 3 billion in illicit funds in property. This is unsurprising given the big-ticket nature of real estate transactions and the sky-high prices of our housing. But it just underscores the importance of enhancing our regulatory efforts in the sector to prevent a recurrence of the events of August 2023. For this reason, there's little reason to reject legislative changes that edify such efforts, and hence I support the bill. Given the importance of the issue, I was therefore surprised to see how the proposed amendments did not appear to be all that extensive. Many of them entail logical but seemingly minor expansions of scope, from changing the term money laundering and terrorism financing to money laundering, proliferation financing, and terrorism financing. Indeed, by my count, half of the clauses in the bill relate to this change. Well, I do not necessarily question the value of enfolding the illicit financing of weapons of mass destruction, or WMD, into the scope of our anti-money laundering regime. It would nevertheless be helpful to this House to understand why this definitional expansion is deemed to be so crucial and relevant for our continued efforts in the real estate sector at this particular point in time. How many of the recent cases that have come under investigation have involved the financing of WMDs relative to plain vanilla AML or terrorism financing? Based on my reading, the remaining provisions introduced are also somewhat fairly mild, changing penalties to each instance of contravention, adding a requirement that unrepresented counterparties in real estate transactions be subject to more scrutiny, and raising the maximum penalty from 100,000 to 200,000. It is only in Clause 10 where there seems, at first glance, to be some real teeth. It proposes amendments to the regulation-making powers of the Council in Section 72 of the of the Estate Agents Act. But when one returns to the original Act, one may be disappointed again. Here, the change is, again, to insert proliferation financing to the list of requirements for what may be subject to regulation. So, perhaps the underlying reason for the seemingly limited slate of amendments to the law is because there is already a robust set of laws in place to ensure the proper due diligence of real estate transactions, even back in 2023. The Council for Estate Agencies, in its guide on 2021 regulations related to the prevention of money laundering and terrorism financing, had already set out a comprehensive set of guidelines for how to conduct customer due diligence, including enhanced procedures for when the risks of money laundering or terrorism financing is greater. The January 2025 version of the guide does indeed update the list of red flag indicators, doubling the page coverage in process. But my point is simply that we will not be bereft of laws to combat so-called Singapore washing, even before this present update. And the government has acknowledged as much. In a response to a parliamentary question posed by my honourable friend, Leong Man Wai, the Minister for National Development indicated that, and I quote, property agencies and property agents are required to perform due diligence checks on their clients before commencing any business relationship or facilitating transaction with them, end quote. Yet, in our conversations with those working in the sector, some have raised a nagging sense that AML procedures in the industry are somehow not as robust as those for the financial sector more generally. The IMC report observed this too, noting that and I quote, uneven implementation practices across and within sectors, close quote. And in response to this clarification question that I had posed on the IMC last year, Minister Indrani conceded that the government had, and I quote, already started to do more in this space, and will certainly see what they can do to strengthen the regulations in the sector, end quote. So the relevant question, beyond whether these changes proposed in today's bill are only marginal, is whether more substantive legislation is actually required to bring the industry to the frontier of AML best practices that the rest of the financial sector in Singapore is required to abide by. I'm not a lawyer, but I would appreciate if the minister would be willing to share if the laws as they stand, together with the amendments proposed today, are indeed sufficient to have brought about an earlier detection and detention of the Fu Tian gang. If so, was it a matter of execution that fell short rather than the legal framework per se? And if not, what laws would be necessary, and why have these laws not been proposed to this House today? The essence of my message, sir, is simple. I do not believe that we actually lack the laws necessary to investigate, apprehend, and prosecute egregious money laundering practices in the real estate sector. What I feel is more important is a steely-eyed focus on ensuring enforcement and compliance, for which I hope the government will redouble their efforts to stamp out the scourge of Singapore washing.